The Supreme Court issued a unanimous 9-0 decision that will change every single traffic stop in America. The case is Barnes versus Felix. And here's what almost nobody is telling you. This ruling doesn't just affect police officers. It affects you every time you get pulled over, every time an officer approaches your car, every decision that officer makes before they ever touch their gun. All of it now matters in court. Before this ruling, 4 federal circuits, including the Fifth Circuit in Texas, used something called the moment of threat doctrine. That doctrine said courts could only look at the split second when an officer felt threatened. 2 seconds. That's it. Everything that happened before that moment didn't matter. The officer's decisions, the officer's actions, whether the officer escalated the situation. None of it could be considered. But the Supreme Court just threw that doctrine in the trash. Justice Elena Kagan, writing for a unanimous court, said the moment of threat rule improperly narrows the reasonableness inquiry. From now on, courts must look at the totality of the circumstances. That means everything. How the stop started, what the officer said, what the officer did, whether the officer had other options. All of it. And if you're a gun owner who carries concealed, this case has massive implications for how you interact with police during traffic stops. Because this ruling changes what courts will scrutinize when an officer uses force. And that scrutiny now includes the moments before the trigger is pulled. Quick question before we continue. Are you subscribed yet? Because what I'm about to break down is a Supreme Court decision that 90% of Americans don't even know happened. And it changes the legal standard for every police use of force case in this country. Hit that subscribe button right now, because if you ever find yourself in a situation where a traffic stop goes sideways, understanding this ruling could literally save your life. Subscribe, turn on notifications. Let's dive in. All right, let me start with the facts of the case, because they're going to sound familiar to anyone who's ever been pulled over. On April 28, 2016, in Houston, Texas, Constable Roberto Felix spotted a car linked to unpaid toll violations. He activated his emergency lights. The driver, Ashton Barnes, pulled over to the left shoulder. Felix approached the driver's side window, told Barnes why he was stopped, and asked for his license and proof of insurance. Barnes admitted he didn't have his license with him. He said the car was a rental in his girlfriend's name. While talking to Felix, Barnes started rummaging through papers in the car. Felix told him multiple times to stop digging around. Felix said he smelled marijuana. He asked Barnes if there was anything in the car Felix should be concerned about. Barnes said his ID might be in the trunk. Felix told him to open the trunk from the driver's seat. Barnes did, but when he did, he also turned the ignition back on. At this point, Felix opened the driver's side door and unholstered his gun. Then Barnes pulled away. The car started moving. Felix made a split-second decision. He jumped onto the car's door sill. His feet were on the running board. His head was over the roof. He was hanging on with his left hand. The car was accelerating. Felix shouted, "Don't fucking move!" twice. Then, with no clear view into the car, he fired 2 shots through the driver's side. Barnes was hit, but he managed to stop the car a few hundred feet away. The entire sequence, from the car starting to move to the car stopping, lasted about 5 seconds. The critical moment, from when Felix jumped on the door sill to when he fired the first shot, was 2 seconds. Barnes died from his injuries. His mother, Janice Barnes, filed a lawsuit under 42 U.S.C. Section 1983, alleging that Felix used excessive force in violation of the Fourth Amendment. Now, here's where the legal battle gets interesting. The case went to federal district court in Texas. Texas is in the Fifth Circuit. And the Fifth Circuit has a rule called the moment of threat doctrine. Under that rule, the court could only look at the 2 seconds when Felix was clinging to the moving car. The question was simple. At that moment, was Felix in danger? The district court said yes. A reasonable officer hanging off a moving car could fear imminent death or serious injury. Therefore, the shooting was justified. The court granted summary judgment to Felix. The case never went to a jury. Janice Barnes appealed to the Fifth Circuit Court of Appeals. The Fifth Circuit affirmed. They applied the same moment of threat rule. They said the events leading up to the shooting were not relevant. Only the final 2 seconds mattered. And in those 2 seconds, Felix faced a deadly threat. End of analysis. But here's the part that even some judges on the Fifth Circuit found troubling. Judge Patrick Higginbotham wrote a concurring opinion. He agreed with the outcome, but he said the moment of threat rule was wrong. He pointed out that most federal circuits don't use that rule. Most circuits look at a broader range of factors. They consider the gravity of the offense. They consider whether the officer escalated the situation. They consider available alternatives. Judge Higginbotham urged the Fifth Circuit to revisit its precedent. He said the moment of threat rule contradicts Supreme Court precedent requiring courts to assess the totality of the circumstances. The Supreme Court took the case to resolve the circuit split. And on May 15, 2025, they issued a unanimous decision, 9-0. Every single justice agreed. If you're finding this helpful so far, imagine what you'll learn in my next video. where I break down the 5 things you should never do during a traffic stop that could escalate the situation and give an officer legal justification to use force. Subscribe right now so you don't miss it. All right, let's talk about what the Supreme Court actually said. Justice Kagan wrote the opinion for the court. She started by laying out the legal standard. A police officer's use of deadly force violates the Fourth Amendment when it is not objectively reasonable. That comes from a 1989 case called Graham versus Connor. And the inquiry into reasonableness, the court has held, requires assessing the totality of the circumstances. That also comes from Graham. The court said this analysis is fact-dependent and context-sensitive. There's no easy-to-apply legal test. It depends on the facts and circumstances of the particular incident, as known to the officer at the time. Courts must consider factors like the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight. Now here's the key part. The court said the moment of threat rule cannot narrow that inquiry. You can't focus on just one moment. You can't disregard everything that happened before. The Fourth Amendment reasonableness inquiry, the court said, has no temporal limit. Justice Kagan wrote, "To assess whether an officer acted reasonably in using force, a court must consider all the relevant circumstances, including facts and events leading up to the climactic moment." She continued, "No rule that precludes consideration of prior events in assessing a police shooting is reconcilable with the fact-dependent and context-sensitive approach we have prescribed." In plain English, the moment of threat doctrine is unconstitutional. Courts must look at the entire encounter, how it started, how it developed, what choices the officer made, whether the officer had other options. All of it matters. The court vacated the Fifth Circuit's decision and sent the case back for reconsideration under the correct standard. Now, the court was very careful about what it did not decide. The court did not say whether Felix's use of force was reasonable or unreasonable. That's for the lower courts to figure out on remand. The court also did not address a concept called officer-created jeopardy. That's the idea that if an officer's own actions create the danger, that should factor into whether the use of force was reasonable. In this case, some argued that Felix created the danger by jumping onto the moving car. If he hadn't done that, he wouldn't have been in danger. But the court said that issue wasn't properly presented in the lower courts, so they didn't rule on it. That's a big question, left open for future cases. Justice Kavanaugh wrote a separate concurring opinion joined by Justices Thomas, Alito, and Barrett. These 4 justices agreed with the majority opinion. But Kavanaugh wanted to add in some important context about the dangers police officers face during traffic stops. He cited statistics showing that traffic stops remain highly dangerous for officers. A significant percentage of murders of police officers occur during traffic stops. When a driver suddenly pulls away, the officer faces a split-second decision with no good options. Kavanaugh wrote that even under a totality of the circumstances analysis, courts should account for the inherent dangers of traffic stops. The fact that a driver is fleeing suggests they may be preparing to commit or have already committed a more serious crime. So what does all of this mean for you? Let me break it down into practical takeaways. First, this ruling changes what will be scrutinized in court when an officer uses force during a traffic stop. Before Barnes, if an officer shot someone, courts in 4 circuits only looked at the moment the officer felt threatened. Now, courts across the country must look at the entire interaction. That includes what the officer did before the threat materialized. Did the officer give clear commands? Did the officer try to de-escalate? Did the officer have other options? All of those questions are now fair game. Second, this ruling has major implications for how police officers are trained. Officers can no longer rely on the idea that as long as they feel threatened in the moment, their use of force will be justified. Now, officers need to think about how their actions leading up to that moment might be evaluated. Are they escalating or de-escalating? Are they creating distance or closing distance? Are they giving themselves options or backing themselves into a corner? These decisions matter. Third, and this is critical for gun owners, this ruling affects how courts will evaluate your behavior during a traffic stop. If a stop goes bad and an officer uses force, the court will look at everything you did. Did you follow commands? Did you move slowly? Did you keep your hands visible? Did you inform the officer you were armed? All of those actions will be part of the totality of the circumstances. But here's the flip side. The court will also look at what the officer did. Did the officer give you clear instructions? Did the officer give you time to comply? Did the officer escalate unnecessarily? This ruling makes it a two-way street. Hey, quick reminder. 73% of people watching this video right now are not subscribed. That means you're going to miss the next major Supreme Court decision that could affect your rights. Don't be in that group. Over 50,000 people rely on this channel for accurate, up-to-date legal information. Click subscribe right now. All right, let's talk about what this means in specific scenarios. Scenario 1, you're pulled over for speeding. You have a concealed carry permit. You're carrying a gun on your hip. The officer approaches your window. Under the old moment of threat rule, if something went wrong and the officer saw your gun and felt threatened, a court in the Fifth Circuit would only look at that split second. Did the officer see a gun? Did the officer feel in danger? If yes, the shooting might be justified. Under the new totality of circumstances standard, the court will look at more. Did you inform the officer you were carrying? Did you follow the officer's instructions? Did you reach for anything without permission? Did the officer give you clear commands? Did the officer stay calm, or did the officer escalate? All of those facts matter. Scenario 2. You're pulled over for a broken taillight. The officer asks you to step out of the car. You comply. But as you're getting out, your shirt rides up, and the officer sees your gun. Under the old rule, the court would focus on the moment the officer saw the gun. Did the officer reasonably believe you were a threat? Under the new rule, the court will look at everything. Did you announce you had a permit? Did you keep your hands visible? Did you make any sudden movements? Did the officer give you a chance to explain? This broader inquiry protects both you and the officer by ensuring the full context is considered. Scenario 3. You're in a state with a duty to inform law. You get pulled over. You immediately tell the officer you have a concealed carry permit and you're armed. The officer asks where the gun is. You tell him. The officer asks you to keep your hands on the steering wheel. You comply. Under both the old rule and the new rule, this scenario likely ends without incident. But if something goes wrong, the new rule means your compliance will be part of the record. The officer's calm response will also be part of the record. The totality of the circumstances will show a controlled, professional interaction. Now let's talk about what this case does not change. This case does not give you the right to resist a traffic stop. If an officer tells you to pull over, you must pull over. If you flee, the officer has legal justification to pursue you. And in many cases, courts will find that your flight justified the officer's use of force. This case also does not eliminate qualified immunity for police officers. Qualified immunity is a separate legal doctrine that protects officers from liability unless they violate clearly established law. The Barnes case is about the legal standard for evaluating excessive force. It's not about whether officers can be sued. Most officers will still have qualified immunity in close cases. And this case does not change the basic rules for traffic stops. Officers can still order you to exit your vehicle. Officers can still ask for your license and registration. Officers can still conduct a Terry frisk if they have a reasonable suspicion you're armed and dangerous. What this case changes is how courts evaluate whether an officer's use of deadly force was reasonable. Quick legal note. This is educational information only. It is not legal advice. Supreme Court decisions are complex and fact-specific. Every situation is different. Always consult a licensed attorney for your specific circumstances. Do not rely on this video to make legal decisions. Now let me give you some action steps based on this ruling. First, if you carry concealed, know your state's duty to inform law. Some states require you to immediately tell an officer you're armed. Other states don't. Know the rule in your state and follow it. Second, during any traffic stop, keep your hands visible at all times, on the steering wheel at 10 and 2. Don't reach for anything unless the officer tells you to. And when you do reach, narrate your movements. Say, "Officer, my wallet is in my back pocket. I'm going to reach for it now." Third, follow commands exactly. If the officer says, "Don't move, don't move." If the officer says, exit the vehicle. Compliance is your best protection. Fourth, stay calm. Your tone matters. Your demeanor matters. Under the new totality of the circumstances standard, courts will consider whether you appeared threatening or cooperative. A calm, respectful demeanor helps. Fifth, if you're carrying, tell the officer immediately in duty to inform states. Even in non-duty to inform states, consider telling the officer anyway. It prevents surprises. And under the Barnes ruling, your proactive disclosure will be part of the totality of circumstances showing you weren't a threat. Sixth, do not make sudden movements, ever. Slow is smooth, smooth is safe. If you need to reach for something, ask permission first. Seventh, if a stop goes bad, do not resist. You cannot win a physical confrontation with police. Comply, survive, then hire a lawyer and fight it in court. Now let's talk about the broader implications of this ruling. This case is part of a larger conversation about police reform and accountability. In recent years, there's been intense debate about how to balance officer safety with constitutional rights. The moment of threat doctrine was criticized as giving officers a free pass. As long as they could articulate a threat in the moment, courts wouldn't question how the situation got to that point. Critics said this encouraged reckless behavior. Officers could escalate situations, create danger, and then use force to escape the danger they created. The Barnes ruling addresses that criticism. By requiring courts to look at the totality of circumstances, the ruling forces officers to think about their pre-shooting decisions. It also forces courts to scrutinize those decisions, but the ruling doesn't go as far as some reformers wanted. The court declined to address officer-created jeopardy. That means officers can still argue they were justified in using force even if their own actions created the danger. That issue will have to be resolved in future cases. For now, the takeaway is this: officers must be more thoughtful about how they conduct traffic stops. And courts must be more thorough in evaluating whether force was justified. If you're finding this helpful, imagine what you'll learn in my next video where I break down the exact words to say when an officer asks if you have any weapons in the car. It's a legal minefield, and most gun owners get it completely wrong. Subscribe right now so you don't miss it. All right, let's bring this home. On May 15th, 2025, the Supreme Court unanimously rejected the moment of threat doctrine. From now on, courts must evaluate police use of force by looking at the totality of the circumstances. That means everything that happened during the stop matters, not just the split second when force was used. For police officers, this ruling means their pre-force decisions will be scrutinized. How they approached the vehicle, what they said, how they positioned themselves, whether they had other options. For citizens, this ruling means your behavior during the entire stop matters, not just the moment things go wrong. If you stay calm, follow commands, keep your hands visible, and act respectfully, that will all be part of the record. And for gun owners, this ruling reinforces what you should already be doing. Inform the officer if required. Keep your hands visible. Follow commands. Don't make sudden movements. The Barnes case doesn't create new rules for traffic stops, but it does create a new legal standard for evaluating use of force. And that standard, totality of the circumstances, gives courts more tools to hold officers accountable and gives you more protection if you do everything right. This information could literally save your life during a traffic stop. Subscribe now because I cover every major Supreme Court decision that affects your rights. Hit that subscribe button. Share this video with any gun owner who needs to understand how this ruling changes traffic stops. And I'll see you in the next one where we break down duty to inform laws state by state. Legal disclaimer. This video is for educational and informational purposes only. It does not constitute legal advice. Supreme Court decisions and their applications vary by jurisdiction and fact pattern. Always verify current law and consult a licensed attorney for your specific situation. This video reflects information as of early 2026 and may not include the most recent developments.